Continuation of discussion in Article 125. Number 1. What are the circumstances considered in determining the liability of an officer detaining a person beyond legal period? For the purpose of determining the criminal liability of an officer detaining a person for more than the time prescribed by the revised penal code, number 1. The means of communication as well as, number 2, the hour of arrest, and number 3, other circumstances such as the time of surrender and the material possibility for the fiscal to make the investigation and file in the time, the necessary information must be taken into consideration. Para malaman ng kriminal na pananagutan ng isang alagad ng batas na nagkulong sa isang tao lagpas sa oras na tinakda ng Revised Penal Code, number 1, ang pamamaraan ng pakikipag-ugnayan pati na, number 2, ang oras ng pagkahuli, at number 3, ibang mga pangyayari katulad ng oras ng pagsuko at ang pisikal na posibilidad para sa pisikal na makaimbestiga at makasampa ng kinakailangang reklamo ay dapat isaalang-alang. Number 2. Will the violation of Article 125 affect the legality of confinement under the process issued by a court? The failure of the arresting officer to deliver the person arrested to the judicial authority within the time specified in Article 125 does not affect the legality of the confinement of the person who is detained because of the warrant subsequently issued by the competent court when the information was filed therein. Ang bigong pagsampa ng kaso sa korte ng humuling alagad ng batas laban sa taong hinuli sa loob ng oras na itinakda ng Article 125 ay hindi makakaapekto sa legalidad ng pagkakakulong ng tao na nakakulong sa pamamagitan ng mandato de aresto na inilabas ng korte pagkatapos na maisampa ang reklamo. Number 3. Will the fiscal be liable for arbitrary detention under 125? If the fiscal does not file the information within the period prescribed by law and the arresting officers continues holding the prisoner beyond the prescribed period, the fiscal will not be responsible for violation of said Article 125 because he is not the one who has arrested and illegally detained the person arrested unless he has ordered or induced the arresting officer to hold and not release the prisoner after the expiration of said period. Kung ang piskal hindi nagsampa ng kaso sa loob ng oras na itinakda ng batas at ang humuling alagad ng batas ay nagpapatuloy sa pagkulong ng preso lagpas sa itinakdang oras, ang piskal ay hindi mananagot sa paglabag sa Article 125 dahil sa hindi siya ang humuli at illegal na nagkulong sa taong hinuli. Pwera na lang kung inutos niya o inudyukan niya ang humuhuling alagad ng batas para ikulong at hindi palayain ang preso pagkatapos ng nabanggit na oras. What is the remedy where a warrant was improperly issued? If the accused was illegally detained because he was arrested without a preliminary examination, what should have been done was to set aside the warrant of arrest and order the discharge of the accused, but without enjoining the judge from conducting preliminary examination and afterwards properly issuing a warrant of arrest. Kung ang akusado ay illegal na kinulong dahil sa hinuli siya ng walang preliminary examination, ang dapat ginawa sana ay itabi na muna ang mandato de aresto at iutos ang pagpapalaya ng akusado pero hindi utusan ang huwes na gumawa ng preliminary examination at pagkatapos ay magpalabas ng mandato de aresto. Number 5. What are the rights of the person detained? Rights of the person detained. He shall be informed of the cause of his detention. Dapat ipaalam sa kanya ang dahilan ng kanyang pagkakakulong. Number 2, he shall be allowed upon his request to communicate and confer at any time with his attorney or counsel. Article 125, Paragraph 2. Dapat hayaan siya, base sa kanyang hiling, na makipag-ugnayan at makapanayam sa anumang oras sa kanyang abogado ayon sa Article 125, Paragraph 2. Number 6. What is the effect if a public officer or employee presents the exercise of the right of attorneys to visit and confer with person arrested? Any public officer or employee who shall obstruct, prohibit, or otherwise prevents any attorney entitled to practice in the courts of the Philippines from visiting and conferring privately with the person arrested at any hour of the day or in urgent cases of the night, said visit and conference being requested by the person arrested or by another acting in his behalf shall be punished by Arresto Mayor. Republic Act 857. Kahit sinong opisyal publiko o empleyado na humadlang, nagbabawal o di kaya pumigil sa abogado na may karapatang magtrabaho sa loob ng mga korte sa Pilipinas sa pagbisita at panayam sa pribado ang taong hinuli sa kahit anong oras ng araw o sa panahong kinakailangan sa gabi. Ang nabanggit na pagbisita at panayam ay hiningi ng taong hinuli o sa pamamagitan ng ibang tao na pumagitna para sa kanya ay mapaparusahan ng Arresto Mayor. Number 7. What is the reason of the provision of Article 125? Article 125 of the Revised Penal Code is intended to prevent any abuse resulting from confining a person without informing him of his offense and without permitting him to go on bail. Ang Article 125 ng Revised Penal Code ay sinasadyang ginawa para mapigilan ang anumang pang-aabuso mula sa pagkakakulong ng isang tao na hindi ipinaalam sa kanya ang kanyang kasalanan at hindi pinahintulutan na makalabas sa pamagitan ng piyansa. Number 8. What is the difference between Article 124 and 125? In arbitrary detention under Article 124, the detention is illegal from beginning. In arbitrary detention under 125, the detention is legal in the beginning, but the illegality of the detention starts from the expiration of any of the periods of time specified in 125, without the detained person having been delivered to the proper judicial authority. Sa arbitrary detention, sa ilalim ng Article 125, ang pagkulong ay illegal mula pa lamang. Sa arbitrary detention sa ilalim ng Article 125 ay legal sa simula pero naging illegal mula sa pagtapos ng alinman sa mga oras na itinakda ng Article 125 na hindi masampahan ng kaso sa korte ang ikinulong na tao.